You think your case is going fine until the offer comes in your way and it's much lower than you expected. And now you're wondering if something you said or signed or posted just blew up your whole settlement. I'm Guy DiMartino, an injury lawyer here in Indiana, and I see this all the time. Smart people making avoidable mistakes that cost them thousands. In this video, I'll walk you through the biggest traps that can wreck your claim before you even realize what went wrong, so you can protect your case, get what you're actually owed, and stop worrying that you might have already messed your case up. If you're dealing with an injury in Indiana and you're wondering why some people walk away with a fair settlement and while others get lowballed into frustration, it usually comes down to one thing, and that is mistakes. The mistakes are not necessarily big ones. Small, normal, totally human choices that feel harmless in the moment but quietly destroy leverage. So in this video, I'm going to walk you through the 5 common mistakes that can ruin an injury case in Indiana and exactly what you should do instead. Quick note before we get started. This is general information, not legal advice for your specific situation. The facts matter, and a small detail can change everything. Now let's start with mistake number 1, because this is the one that actually happens the fastest, usually within 48 hours. After an accident, the phone rings. A day or two later, an insurance adjuster calls and sounds very polite, sometimes even helpful. They'll say things like, "I just want to get your side of the story," or "This will help us move your claim along faster. Here's what you need to understand." Adjusters are trained to protect the company's bottom line. Their job is to pay you as little as possible and to get the file closed. And the way they do that isn't always obvious. It's not always yelling or arguing. It's sometimes just getting you to talk. Because if you say something innocently, it can be used to minimize your injuries at a later date. A classic example is this. They might ask you, "How are you feeling?" And you answer like a normal person, "I'm okay," or "I'm fine," or "I'm just a little sore." Then weeks later, when the adrenaline wears off and the doctor finds something more serious, the insurance company points back to that first call and says, "They told us they were fine. They told us they were a little sore." It's unfair, but it's common. Another trap that they might get you into is this recorded statement. They'll frame it as very routine. They'll imply it's required. It isn't required in Indiana if it's the other insurance company. You're not required to give a recorded statement. Understand that. So here's the safer move. Keep it simple. Tell them you're not ready to discuss it and you'd like to speak with an attorney first. Then just stop talking. You're not being rude. That one decision protects you from accidentally handing them the very words that they'll use to reduce your settlement 3 months down the line, 6 months down the line. Now, mistake number 2 is just as common as number 1, and that is insurance companies love gaps in medical treatment. After a crash, a lot of people want to go home. They feel embarrassed. They feel shaken up. They assume the soreness will just fade away and get better in a few days. But if you don't get checked out soon after the injury, the insurance company will argue that you weren't really hurt, or the injury wasn't caused by the accident because you don't have that causal nature in time. In Indiana, medical records are very important, and they are the backbone of your claim. If you wait days or weeks, the insurance company will point to the delay and say something like this: "Well, if you were really hurt, you would have went to the doctor." Or, "Why didn't you see the doctor sooner?" Worse, they'll argue something else must have caused it. They can tell a jury, "Well, we don't know what happened in the 7 to 10 days before she went to the doctor. Maybe she was shoveling snow. Maybe she was picking up her kids. Maybe she tried to lift something off the closet shelf." I've seen this happen right here in Indiana so many times. Someone feels sore after being rear-ended, waits almost 2 weeks, and only goes in when the pain becomes unbearable. Why do they do that? Because they don't want to be that person. That delay alone becomes the reason the insurance company suddenly acts like the case isn't worth much. So the rule is simple. Even if you think it's minor, get checked out promptly. Go to the ER, go to urgent care, go to your family doctor, then follow any treatment plan that they give you. You're doing it for you, and you're doing it if you decide that you want to go ahead and bring a case. This is consistent. If you're injured on day one and you go to the ER, and the ER record documents that you have neck pain, and then they tell you to follow up with your doctor. And you follow up with your doctor in the next week or two, and you go to your doctor and you say, I went to the ER, I had neck pain. My neck is still hurting. You see, this requires a clean and provides a clean timeline and a clear record that ties the injury to the accident. You went right after the accident, you complained of neck pain. You followed up a week or two later, you complained of neck pain. Now, once you've done that, you might think you're safe. But mistake number 3 has ruined more cases than most. And that is because people feel that it's harmless and it's even positive. This includes Facebook, Instagram, TikTok, anything that can be taken out of context at a later date. So after an accident, it's natural to post an update. People want support. They want to explain why they're missing work, or they want to explain why they're stressed. I just talked to the insurance company. I got to deal with the body shop, whatever it may be. But what you post can and most likely will come back to haunt your case. Insurance companies look at social media. They search profiles. They look for anything that they can use to argue you're not hurt. You're not hurt as much as your claim. Or you did something during the interim which made your condition worse. So if you post a picture at a family gathering and you're smiling, they'll say, oh, you look fine in that picture. Or if you post something because you had a good day, hey, I'm feeling better today. And then 2 weeks later, a week later, you start to experience the pain again. A day later, they would say, aha, you said that you were better at that point in time. You see, that causes inconsistencies in your story. So even a short video of you sitting at a sports event can be spun into they're exaggerating. They are making up their claim. So even if you were in pain the entire time, the picture's not going to show your pain. And even if you barely made it through the event and you went because it was your grandkid, just be careful about you posting and how other people post or tag you. And here's the part that most people don't understand. Even if your account is private, posts can still surface during the case through the legal process. It's not a guarantee, but it's a risk you do not want to take. So the safest move is don't post about your accident. Don't post about your injuries or your activities while your claim is open. If you're tempted, talk to your attorney first. And one important warning, if you've already posted something and you're listening to this video, don't delete it. Deleting these posts can make you look suspicious, and that can create even bigger problems down the line. If there's something you're worried about, get guidance right away to handle it. Now to mistake number 4. And this is where people can lose their entire case, even if their case is very, very strong. Indiana has deadlines that can wipe out your rights if you miss them. For many injury cases, it's generally 2 years from the date of accident to file a lawsuit. However, there's certain circumstances where you need to file a notice of the claim within 6 months or 9 months, depending upon the entity. If you miss those deadlines, even by a day, you might lose your right to recover anything, no matter how injured you are. But it even gets trickier. If there's a governmental agency involved, if there's a city vehicle If there's a school involved, there's a number of hoops that you must jump through in these situations. If you miss those timelines, your case can go away because courts will not have jurisdiction. On top of that, there are practical deadlines. You need to get your records. You need to respond properly. Waiting too long and getting evidence, getting photos, all those things can just impact your case, right? So if you were involved in an accident while the corn was high in an area in July and August and September, and you go ahead later on in March or in May and take pictures of the scene is completely different. It doesn't show the visual lines of what's going on. So the move here is not to memorize every rule. The move is to get advice early so someone can track the timing and protect your options while you focus on healing. Now, mistake number 5 is the one that feels like relief in the moment and regret later on in your claim. After an accident, bills start to pile up, work gets missed, life gets stressful, then the insurance company offers you a quick check, and it's tempting to take it and move on with your life. But when they come and they offer you that quick hit, that quick check, just take a breath in. Take a moment and think about it. Most of the time, early offers are designed to get you to settle quickly before you know the nature and extent of your injuries or how things are going to shake out, so the insurance company can just close your file, which is assigned a number. It's not to make sure that you get the fair compensation that you deserve. And once you sign the release, your case is done. I can't help you. No lawyer can help you undo that signed settlement release. So if you accept it, and then 2 weeks later you find out you need surgery, you have to live with those consequences. I've seen people settle quickly, then get hit with new information from a doctor weeks later, or they receive bills that they didn't know that were out there months later. They signed the release, they didn't get enough money for the compensation for their pain and suffering. Their bills weren't paid, and they have to pay those bills out of their pocket. So here's the smarter approach. You even have 2 years from the date of the accident. If you have to file the notice requirements, you just have to get those notice requirements in. Don't settle until you understand the nature and extent of your injuries, what the treatment plan looks like, and what the future might require. That includes future care, future lost economic impact, and pain and suffering, not just last week's emergency room bill. And if an adjuster is pressuring you to settle and they're saying, this is the best offer you're going to get, it's only out there for a day or 2 days or a week, you have to ask yourself, why are they doing that? It's usually a sign that you're being pushed towards a number that benefits the insurance company and not you. Now let's recap what you've just learned, because this is the checklist that protects your settlement value in Indiana. First, don't talk to the other driver's insurance company without legal guidance, especially not a recorded statement. Second, get medical care promptly and follow the treatment plan so the timeline is clean. Third, stay off of social media while your claim is open. Fourth, respect deadlines, including special rules that can apply when a government entity is involved in your case. And finally, don't settle until you understand the full cost of your injury, including what comes next in your life. If you avoid these mistakes, you are protecting your rights and you have leverage. And if you want the next video that fits perfectly with this one, watch the one about damage after a semi-truck collision in Indiana, because truck cases involve categories of compensation most people miss, and missing even one of these categories can cost you thousands. Click the next video now, and I'll see you over there.